Mr. President, for the past year, the Senate has engaged in a serious bipartisan effort to reform a controversial spying authority known as Section 702 of the Foreign Intelligence Surveillance Act, or FISA. I have never questioned that Section 702 is a valuable tool for collecting foreign intelligence. Congress' intention when we passed Section 702 was clear as could be. FISA Section 702 is supposed to be used only for spying on foreigners abroad. Instead, sadly, it has enabled warrantless access to vast databases of America's private phone calls, text messages, and emails. This powerful tool has been misused, sadly, in the United States to spy on protesters, journalists, and even members of Congress. Last Friday, the House of Representatives passed an alarming bill. It is misleadingly called the Reform, Intelligence, and Securing America Act. That rather than fixing the flaws in Section 702, the House bill will dangerously and unnecessarily expand it. The Senate is now rushing to pass the House bill as is because FISA Section 702 will sunset on April 19th. But that is a false choice. No member should be fooled into believing that Section 702 will go dark and not be available to be used on April 20th if we do nothing. We planned for this exact scenario by providing clear statutory authority to continue surveillance under existing orders from the Foreign Intelligence Surveillance Court, known as FISC, after Section 702 nominally expires. In fact, the U.S. Department of Justice has already obtained a fresh one-year certification from this court to continue Section 702 surveillance through April of 2025. Let me repeat that. Existing Section 702 surveillance can continue through April 2025, even if it nominally expires on Friday. There is no need for the Senate to swallow whole a House bill that expands rather than reforms Section 702. The House bill contains several alarming and unnecessary expansions of the government's authority for spying. The bill could allow the government to force ordinary U.S. businesses with access to communications equipment, like a Wi-Fi router, to give the National Security Agency access to their equipment. This would greatly expand the number and types of companies forced to assist the NSA with spying and increase warrantless collection of America's communications. Another provision in the House bill would authorize the use of Section 702 data by immigration authorities. I'm very concerned that that would allow a future administration to target dreamers and other non-citizens who are only applying for travel documents and are subject to extensive background checks in that capacity. Rather than expanding Section 702, Congress should reform this authority to protect Americans' privacy. Unfortunately, the purported reforms will have little or no impact. For example, the bill would prohibit what's known as evidence of a crime only queries. This would have prevented the FBI from accessing Americans' communications in only 2 cases out of more than 200,000 searches on U.S. persons in 2022. Other changes merely codify existing internal approval requirements. But with these limits in place, the FBI still conducted an average of more than 500 warrantless searches of Americans every day in 2022. Mr. President, I'll try to make this as basic as I can. After 9/11, we were seriously concerned about the security of the United States, as we should have been. We established authorities of this government to keep us safe. But we had a problem that we had to reckon with. And the problem was this. Despite the great threat we faced, we also had a great responsibility to this publication, the Constitution of the United States. And so we created Section 702 and said we will use it to have queries and surveillance of foreigners in foreign lands, but not Americans. Why did we draw that distinction? Because the Constitution makes it clear. Before the government can listen to my phone call, read my text, or email, in this country, since I'm a U.S. citizen, they have to have a warrant which gives them approval for that search, and they have to go to court to get the warrant for that purpose. We made the exception for foreigners in foreign countries, but we said we were trying to protect Americans from this kind of surveillance without complying with the Constitution. Well, over the years, sadly, the application of this law was not very good. At one point, there were 3.4 million inquiries of American citizens in 1 year. The agencies of our government said, well, we're going to do better. We won't be invading the privacy of individual American citizens. We'll do better. And they did better. But there's still an outrageous and unacceptable level of the misuse of the FISA authority to have surveillance into the privacy of individual American citizens. And that's why I rise today. After the long history of the abuses of this authority, spying on Americans without the constitutional warrant as required, Congress should not rely on internal executive branch procedures as a substitute for court approval. If the government wants to spy on my private communications or the private communications of any American, they should be required to get approval from a judge, just as our founding fathers intended in writing the Constitution. A bipartisan amendment in the House would have required the government to obtain a warrant before searching Section 702 databases for the communications of American citizens. But this critical reform narrowly failed on a tie vote, 212 to 212. I want to offer a narrower amendment that would only require the government to obtain a warrant in a small fraction of situations where it actually wants to read or listen to private communications of American citizens. The vast majority of warrantless FBI searches on U.S. persons do not return any results. Less than 1.6%. Less than 1.6% return any measurable results. Based on recent FBI statistics, that would amount to just 80 times a month that the FBI or other agencies that are engaged in this 702 surveillance would have to ask for a court order to protect inquiries and investigations into private communications of American citizens. I've sat through numerous classified briefings on Section 702 and listened carefully to the government's concerns about having to obtain this court approval in order to review the contents of American communications. My bipartisan amendment accounts for these concerns by providing exceptions to the warrant requirement for emergencies or cybersecurity attacks or where an American certainly consents to the search. This will ensure that there won't be any delays that jeopardize national security. What it will not allow are fishing expeditions in which there are no unusual circumstances and the government does not have probable cause. This pragmatic approach, respecting the Constitution, will safeguard American privacy and still preserve Section 702's critical value for collecting foreign intelligence and protecting national security. The chair of the Independent Privacy and Civil Liberties Oversight Board conducted a thorough review based on a classified record and reached the same conclusion. Congress has a responsibility to the American people to get this right. I recognize the importance of Section 702, but we should not rubber stamp the House's flawed bill where surveillance is already authorized until April 25. I want to respect the need for Section 702, but I'm sworn to respect the need to follow this Constitution. Without critical changes to improve this bill, I cannot support it. And I yield the floor.